All right, then, welcome. Thank you very much for joining us all today on this sunny Thursday afternoon, morning, evening, or wherever you are in the world. This is a roundtable presented by the Centre for Law and Social Change based in London, UK. The Centre for Law and Social Change is a hub for connections, encouraging interdisciplinary and cross-sectoral and intergenerational collaboration on the topic of law and social change. And it is a space to generate debate between scholars, students, practitioners, and organizers, with a focus on progressive social change and a commitment to active anti-racist, feminist, and decolonial practice. So our discussion today will be hosted by myself. My name is Grietje Buijs, also known as River amongst friends and comrades. I'm one of the directors of the Centre for Law and Social Change here in London. And our guests today are two philosophers, Tabji Garba from York University and the author Cordelia Belton. I'll first give a quick introduction, and then we will move to each of us saying a little about our work and how Pashukanis features in it. And then we will have a short discussion before opening it up to all of us here on Zoom. We're also recording the session and we'll publish the recording on our center's YouTube page. So if you go to YouTube and just search for Centre for Law and Social Change, you'll find that. And of course, if you do say anything in the discussion you'd rather not be published, then please let us know. You can send us an email afterwards or write in the chat or whatever. Okay, so our roundtable today is part of a new global network of scholars gathered under the title Pashukanis at 100, celebrating the centenary of the publication of Pashukanis' book, The General Theory of Law and Marxism. I have my very battered and tabbed copy here. You can also get a much newer version from your local bookshop. So Yevgeny Pashukanis was born in 1891 and died in 1937, and he was perhaps the most important Marxist theorist of law. His work not only inspired early Soviet jurisprudence, but also continues to stimulate new waves of Marxist legal thinking and philosophical thinking, as we'll see today, including that of myself and also that of our guests today, and hopefully some of you in the room as well. To celebrate the 100th anniversary of Pashukanis' landmark text, a group of Marxist scholars from around the globe have organized a number of events, starting in January with a conference at Queen Mary, organized by Tanzil Chowdhury in Evananopolis. That was really great. There's been a series of events, and there's also some still upcoming, including a conference in Brazil and one in Sweden. So we are celebrating and exploring the significance and enduring relevance of Pashukanis' work, not only for law and legal scholarship and philosophy, but also importantly for our politics and our Marxist political strategy today. And you can check out the Legal Form blog, for more info on the upcoming Pashukanis at 100 events. And you can also follow us, the Centre for Law and Social Change, on Twitter, where we will announce and retweet any upcoming events and all our other events as well. So this roundtable today is entitled Pashukanis and the Turbulence of the Present. So Pashukanis argues that capitalist social forms are inseparable from legal subjectivity, and the transition to communism means overcoming both law and the state. We live today in a period of transition characterized by the rise of fascism, right-wing nationalism, international conflict, genocide, and climate instability. In this roundtable today, we will discuss law, transition, and crisis, followed by a conversation where we try to link theory to praxis. We consider the following questions. What would or does the transition to a world beyond law look like? What would be needed in terms of alternative practices, spaces, and social forms? What do we need to destroy, including structures and ideas? And what do we need to build? Who or what can we draw inspiration from? And what are we and other people already doing? So I'm going to hand over to Tabji in a minute, but I'll introduce this all properly first. So Tabji Garba, they, them, is a PhD student in social and political thought at York University, and they work on political theology, political economy, and Black studies. Then we also have Cordelia Belton, she, her, who is a communist political philosopher based in Chicago. She's the author of a forthcoming book, Making the Case Against Money, Markets, and Value, and for a particular conception of communism to political theorists. That sounds great. I really can't wait to read that. She also works in the philosophy of economics, social ontology, and normative epistemology. And then there's me, Gietje Baars. I also use they, them pronouns. And I work on the relationship between law and capital using queer and Marxist theory to understand and ultimately subvert the constitutive ordering and ideological functions of law. And I also have a background in corporate legal practice and international law, including 3 years working in Palestine, which was where I first read Pashukanis and China Mieville's amazing book on international law based on Pashukanis' general theory, and which made me, that combination made me the Marxist I am today. I am currently a reader at the City Law School here in London and moving to SOAS in the 2nd of September. I'm a founder and co-director of the Center for Law and Social Change, together with my other co-directors here in the room, Susanna Bartik-Kirchmann and Santosh Anand. So we're going to start the roundtable today with Tabji, and then we'll move to myself, and then we'll turn to Cordelia before we ask the questions and have a more broad discussion. And we'll bring you, all of you, into the discussion, those of you who'd like to join at least, in about 30 minutes from now. So over to you, Tabji.
Okay, hello. So I think I will frame the way Pashukanis enters my work in sort of two directions. There's a genealogical side and there's a more constructive side. So on the genealogical side, some of the main things I work on involve early modern and late medieval debates on property law. And with friend Sarah Maria Sorrentino, we're currently writing about one chunk of debates in particular on voluntary slavery. In Roman law, it's written that like parent or whoever, in cases of extreme necessity, like if you're going to starve to death or something, you are free to sell yourself, to alienate your will in order to survive. So that's a lawful thing that you can do. This was the topic of debate amongst the Jesuits in Brazil in the 1600s, when the two reasons. First, when indigenous people started volunteering themselves to work for the Spanish and the Portuguese. And they had a discussion about whether this is lawful, considering all the other things that were happening to indigenous people in Brazil. Is this an extreme necessity that is being imposed by us, the Portuguese, or is this something else? If it's imposed by us, then this might not be lawful. If it isn't imposed by us, maybe it is. So there's that whole debate. And then second, it's about the transatlantic slave trade and what makes it legitimate or not in the absence of conquest, the usual justification for slavery. One of the underlying kind of features of this discussion, or what's at stake, is the matter of what a legal subject is, and specifically the assumption that a legal subject is someone who has mastery over their will. And I think as well, mastery over one's body, that it's a thing that you own, that you can give away. The outcome of these debates, to really condense them on this front, is an idea where there's a split between the ownership of one's body and possession of one's body. So you can give away aspects or parts of yourself for limited amounts of time without thereby giving away ownership. And this is the form of contract that come to all be familiar with in Marx, for instance, in the wage contract. That what makes it different from slavery is that there are time limits on how long you're selling yourself for. And this is what brings me to Pashukanis, because that's kind of the heart of the form of law that he's concerned with. So when I was doing my master's research, there was a particular quote from Pashukanis that I found really striking, and that kind of brought me to looking into the voluntary slavery stuff, which is that he says, talking about how once people are like dispossessed of land and subordinated to the wage relation, they are gifted a will, that legal freedom and status is something they're gifted. They're gifted ownership over themselves. And they're gifted the ability to voluntarily submit to other people. So that was the piece that initially interested me. The second one was a quote he used from Victor right after describing the body as a tool to be freely used by the will, which is a recasting of Aristotle's understanding of master and slave, where the slave is a tool of the master, except now the body is the tool of the will. And thirdly, I think what made Pashukanis really interesting, since some of these points are there in Marx, is that his solution to these problems is like distinctly not Marx's in striking ways. The fact that it's not a question of how can we sort of realize the promise of freedom, but it's actually just the thing that needs to be overcome. It's, for him, communist transition isn't really about achieving sort of higher development of legal autonomy or autonomy beyond value or something. The whole gambit of ideas of will, freedom, etc., are inseparable from contract, from property, and so on. So that's what makes him really unique for me. And why I think in both on the genealogical side and on the constructive side, why he's been a figure of interest. So that's what I'll say for now.
Great, thank you, Tabji. It's really interesting to hear your different but similar interpretations. So I suppose since we're all coming from different disciplines, we read Pashukanis differently, but we agree on the core ideas. Somebody's asking in the chat, what text is the quote from that people are gifted legal status? I know that in the general theory, Pashukanis also talks about that, and that's going to come up in my talk as well. So I'll perhaps point that out. Okay, so I started by saying earlier that I have this background also, having worked in corporate law, right? And then I was always a Marxist. I just wanted to see what that world was like from the inside, right? But I learned a lot there actually, and also learned a hell of a lot working as a human rights lawyer in Palestine. And I think that both of those combined really made, when I read, when I went to Palestine as a human rights lawyer, thinking, okay, this is the work we're doing here, I could see that law wasn't helping the situation. Not that, I mean, with whatever is going on, law is not the tool that will liberate Palestine. And I think reading Pashukanis allowed me to understand that in a theoretical sense, as well as a sort of a more of a lived experience kind of sense. So my work more generally is on legal subjects and the legal relations that constitute those subjects. I've worked in the past on the corporate legal subject, so that was my PhD topic. And corporate accountability for war crimes and human rights abuse is also connected to the work I did in Palestine from a Marxist and abolitionist perspective, which I'll argue are the same thing, and, well, could be the same thing, and on the creation and regulation of the categories of gender and sexuality through law. My first book, my PhD text, is now published by Historical Materialism through Brill and Haymarket, and is entitled The Corporation, Law and Capitalism, a Radical Perspective on the Role of Law in the Global Political Economy. And I'm currently working on my second monograph entitled Queer Subjects of Capital, in which I bring the two together. So the creation, construction of the gendered and sexualized subject and the corporation, or through the corporation even, because I'm looking at Dutch East India Company sodomy cases in a Dutch colonial context to sort of make an argument about the relation between sexuality and capital. So we said that Pashukanis is one of the most important theorists of law, if not the most important, and I want to claim that his general theory is what Marx would have written if he, and of course he also was legally trained and wrote his PhD in law, would have lived to complete his text on law. So what the general theory gives us is a fundamental importance for liberation and revolution today, a reinforcement that this will only come through the withering away, the abolition, or the smashing, to use a term that's closest to the German brechen, which Marx and Engels used, of the state and state institutions, including significantly law. And legal institutions like courts and the legal system as a whole. With law not being some kind of third neutral force out there, but a fundamental part of the way the state and capital are both constituted and operate within society. Law is inherently violent and does not have revolutionary potential. Revolution will not be legislated nor litigated, and this lesson from Pashukanis has fundamental impact on how we organize for the revolution today. In particular, I would say in Europe and the US, where we are still most in awe of law. Something I'll come back to later on in the conversation. Now, most Marxist approaches to law, such as those by E.P. Thompson, Poulantzas, B.S. Chimney, and Samir Amin, both international law scholars, understand law as an instrument of state power or class power. One of the main methods for Marxist legal scholarship then has been a historical materialist or workers' inquiry into what some might call the factory of law, where the norms are produced. This factory could be a literal factory, or it can be the home, the street, the social movement, or the even international society, or wherever we are. And this involves asking how norms came to be, have their current content and application, how the relations of production and the relations of power are reflected by and obscured by contestation over legal norms. And we can see this in Marx's own writing on the theft of wood, for example, and in his chapter of Capital on the Factory Acts. But we need to go deeper than this. We need to understand what exactly law is and why law specifically is such a useful tool of state and class power. So the specific lawness of law, an analysis of the legal form, and by extension, the nature of the legal subject within capitalism, that is precisely what Pashukanis' commodity form theory of law elucidates. So the legal subject that Pashukanis theorizes around is, of course, at base or initially the white propertied, heterosexual, able-bodied middle class, or becoming middle class man, who sits at the nexus of the legal relation brought into being by and for commodity exchange. So Pashukanis approximates the legal form to the commodity form, and modern systems of law consisting of rules promulgated by parliaments, interpreted by courts, and enforced through the legal force of contract, as well as the actual and potential actual violence or threat of violence, physical force of the police and the criminal justice system, emerged as part of the formation of the modern state system in the transition to capitalism. The law, with its particular origin point in this moment, generalized in the transition, is of a different nature than the rules and edicts issued by feudal princes, emperors, as well as religious authorities up till then. So Pashukanis, in his general theory of law, locates the need for and the emergence of this new form of law in the development of the modern idea of private property. The legal concept of private property, as Tabji also talked about, is the basic norm, or we might say the Grundnorm in legal terminology, upon which the modern legal systems are constructed. To give effect to the notion of private property, relations between human persons had to be transformed into legal relations, and law had to construct the human person, or as I mentioned, a particular type of human person as legal subject. So as shown by Marx and E.P. Thompson, amongst others, the transition to capitalism, of course, was enabled through law. When common land was legally enclosed and commodified, living of the land was criminalized through laws on the theft of wood and vagrancy. This meant that production was forced out of the home and into factories. Production for subsistence as a general mode was supplanted by production for exchange. And besides the laws that forced this transition, law was needed in order to enable this exchange. As Marx put it, commodities couldn't take themselves to market, so a legal person was needed who would recognize the exchange partner as a property owner and formal legal equal, thus erasing their material inequality, making that invisible to the law, to negotiate and agree contractually their price. As Pashukanis puts it, the social relation which is rooted in a production presents itself simultaneously in two absurd forms, as the value of commodities and as man's capacity to be the subject of rights. So at the same time, in the early 17th century, another legal person, the corporation, the company, was specifically constructed to make possible the predatory expeditions of the Dutch and British East India companies, corporations which back then had much the same form as they do today, were as capital personified, the engine that drove European pillage, plunder, and colonization of much of the global south. This is what I call the imperialism of the corporate form. It is legally structured to maximize profit extraction and to avoid losses or payments for harm. The notion of the limited liability of shareholders which turns cooperation into an externalizing machine, what I call the imperialism at the heart of the corporate form, allows the colonial corporations to spread capitalism around the world, the European corporations' capitalizing mission as such, and replicated, multiplied, and optimized their legal forms also through colonial governance, forming a blueprint for the so-called post-colonial state. A key aspect of this imperialism is the corporate enslavement of and trade in upwards of 13 million Africans, which laid the basis for the racialized violence of today's global corporate capitalism. So significantly, of course, for our purposes, this changing economic system, the transition to capitalism, required different types of workers, and gender, race, and sexuality were constructed to group, differentiate people, and make them available for exploitation and vulnerable to premature death, to use Ruth Wilson Gilmore's words. Now, that's something I work more in the current project, and that also Tabji works on and is written very eloquently on. I recommend that you look up Tabji's articles on academia if you have access to that. And so one of the issue of legal subjectivity with this particular sort of particularly categorized as racialized, gendered, sexualized, etc., creates its own dynamic. And through this sort of acquisition of the legal will, right, of the will to have rights, that is the power of the legal subject form. The fact that the creation of the particular categories of subjectivity makes us desire the completion, the acquisition of the full complement of rights based on that particular subject category. That is our sort of internalized, perhaps even might use the term voluntary slavery for the system of law, the legal system. That is what subjects us to the capitalist legal system. And that is one of the avenues to which our emancipation must come. So modern law posits the individual as an actual or potential rights-bearing legal subject capable of owning property, separated by its subjectivity from the collective social, entered into competition and contestation with other rights-holding legal subjects to protect their property, which is as much mine as it is therefore not yours. My property gives me the right to exclude you from it as well. Capitalist law and legal systems exist to uphold and protect private property, the norm at the core of the capitalist system itself. Property ownership involves my relation to the property and my right to exclude you. This is what China Mayville identifies as the violence at the heart of the legal form itself. Okay, so I'll leave it there, and I'll pass over to Cordelia because I think I've been talking for too long. But yeah, we'll come back in the questions tomorrow. Okay, Cordelia, take it away.
Thank you so much for both of your talks, Tapji and River. I thought they were so rich, and Tapji in particular. I had on my mind as I was going over my notes today, two of the three passages I talked about, I think, were the two that you mentioned from Pashukanis offhand. So instead of reading or summarizing them to you again, I also will offer a little prehistory of how I became interested in Pashukanis's work, and the kind of odd direction that I think it would be fruitful to go with him. So my interest in Pashukanis is broadly a sequela of something like interest in the resurgence of new Marx readings in the academy. Among them, in particular, the Neue Marxlehre, open Marxism, the value form theory, all of which purport to be reading Marx in a light other than that which he was read in the post-war 20th century, in particular in the Anglo-American Academy. So there's a lot of work on Marx and political philosophy. A lot of words have been shed on socialism in something like political theory, political philosophy over the past 40 years. Marx is read habitually as something like a desert theorist, as in workers ought to get more than they do, or as a left egalitarian in the vein of Jerry Cohen. And none of these are really terribly compelling. They don't seem to square with Marx, and neither do they seem to offer very much new to us. And so the common thread to something like these new readings, ordinarily, is that they make the case in broad terms that something that generalized commodity production does to us, some way it affects us, violates something like a kind of freedom, it's a form of compulsion, it's a bad kind of mediation. And there's something very genial, there's something that I find very instinctively sympathetic about these arguments. But there's also a point where you kind of start to wonder, okay, and what then? Can you talk about what it's like to live without this kind of bad mediation or to have this kind of freedom? And the answer is, I think, not really in these texts as they stand. And so this kind of limits the conditions by which they might interface with the rest of political philosophy or political theory in general. This is, I think, why they are not really assimilable to something like the repertoire of political philosophy, why you're not really able to convince the left egalitarian you talk to why we oughtn't have commodities, markets, and money. And so on the second arm of this is that I'm a little bit, for reasons relatively similar to the genealogical reasons that, as well as functional reasons that Pashukanis gives, skeptical of our free appropriation of concepts like freedom and justice, as we pull them out of an ethical tradition that, as Pashukanis argues, I think quite successfully, is at its base offering at times something like a post hoc rationalization for, or alternatively, the conditions for our exchange as commodity bearers. And Pashukanis, I think, probably stands alone within the tradition of communist Marxian 20th century theorists in similarly reading Marx as doing something which is meaningfully outside desert theory, egalitarianism, what have you, and at the same time is quite skeptical of kind of free appropriation of the concept of freedom, and one that Marx himself is pretty free with. So Tapti called our attention to Pashukanis's deployment of Fichte at one point of general theory. Fichte, he says, Fichte talks about the coexistence of many free beings who shall all be free, the freedom of one not interfering with the freedom of others. And Pashukanis says, Fichte, this is an idealized market. But the one other irony that I would call our attention to is that in the text of Fichte's Rechtslehre, which Pashukanis is citing, there are two interesting things happening. One is that Fichte, in attempting to defend and sketch this conception of freedom and he sketches as well a kind of theory of the state, which is supposed to realize it, actually begins with taking as his desideratum something like the concept of free association. So, okay, where have we heard this one before? And then the second is that Fichte is, of course, reading in the Rechtslehre the same sections of Aristotle's ethics as Marx is in Capital. And so Pashukanis, I think, is very nearly ready to say something like, we need to talk about how to live together as communists in a way which eventually no longer is in terms of ourselves relating as sort of individual subjects with various relationships to commodities and picking up torts as other people wrong us and this and that way. And so I think there are three little fragmentary places where Pashukanis is very nearly ready to take a fairly substantial step beyond Marx. And schematically, because I don't want to go on, I'll say there's something like this. The first is he has a set of relatively enigmatic remarks on the ambiguity of the ethical. So Pashukanis engages in what we would talk about in recent work in analytic philosophy as both historical genealogy and functional genealogy. He has a story, an actual historical genealogical story of how legal categories came about. And he offers a functional, or you could say also imaginary genealogy, sort of like Williams style, of what it is these categories do, i.e. what they do for generalized commodity production. And he makes the case that these are working at cross purposes. He says, on the one hand, you can't apply ethics outside of commodity producing society. And then on the other hand, he also says that when he brings up ethical doctrine as he thinks it interfaces with communism, communism abolishes ethics. He says also that communism realizes his particular version of ethics. It's both totally unimplementable and also somehow, when we're talking communism, we're talking the kind of like, he says, pure, and we're talking about a relatively simple means of articulating how we come to interact with one another from, he says, the concepts of benefit and harm. The next thing he does, right? So we have the ambiguity of the ethical, they pull apart. He says utilitarianism abolishes ethics by replacing good and evil with harm and advantage. And so it's clearly right. This is, I think, quite unusual that Pashukanis in his mentions of utilitarianism, and again, Bentham, really has only positive things to say, which is at odds with Marx's remarks on that English shopkeeper. And then finally, Pashukanis has a fragmentary remark on what he says is required by the concept of communism. And so, like I said, we are building and conceiving, or as Topji said, constructing of our interrelations in terms of concepts that at some point, as law withers away, as Pashukanis is fond of saying, will no longer bear the distinctive traces of commodity producing society. And so in my work, insofar as the kind of key thing that I try to do in political philosophy is to bring to bear something like this non-desert theorist, non-egalitarian reading of Marx on something like political philosophy in general, so that you can make the case even prior to historical contingency at the level of the ideal average, why this way of relating to each other doesn't work. And yet at the same time, I think like Pashukanis, we have good reason to be skeptical of describing this simply in terms of a kind of like characteristic lack of mediation, a kind of characteristic freedom, being able to engage in a kind of activity without others messing with me. And so we might want to be skeptical of that, not only because, well, it actually isn't others-minded, but also because I think, and the core contention that I want to make, and I think Pashukanis is at various points nearly ready to make, is that when we take issue with something like value or generalized commodity production. The actual issue that we're taking is with its judgments and the way that it judges for us. And I think Pashukanis views in this wonderfully open, constructive way something like the question of socialist construction, or really, because he is at heart a stagist, of something like the construction of communism, as something like constructing the ability to form judgments on the things that we want to do, the things that we could do, the kinds of social decisions that we make, which totally obviate the kind of judging work that markets and money already do for us. And I think quite rightly, he views this as an open-ended, constructive question. And I think what I want to argue for in my work, and which I think lines up quite nicely, is that what it means to do something like get rid of money and to still be doing things which meaningfully break with what money does for us, without, attempting to arrive at a kind of system of trade-offs that replicate something like a very idealized sketch of a capitalist economy, is to construct this system for socially judging, which can substitute in a real way for the places where we now defer to the kinds of judgments that are embodied in money. And so this is all to say that I think Pashukanis has an exceedingly interesting project. He's not only an adept legal theorist, anti-legal theorist, he also tosses off in the course of his argument a kind of historical genealogy of ethical categories, a functional genealogy of ethical categories. He then argues that for ethical categories that entail something like subjectivity, liberty, freedom, are all both ultimately bear the kind of hallmarks of commodity producing society and ultimately re-entrench it. And then he offers a very, very brief few remarks on just what it is that it would mean to construct a society where we didn't have to interact with each other in this way. And so in a particular light, I think an exceptionally rich project, and one in which I would take interest, would be expanding those three sort of side projects for him that occur in the course of the general theory, and in particular opening up a discussion on the third of those. And with that, I'll turn it back over to discussion.
Great, thanks so much, Cordelia. That was very, very rich. And of course, I feel that your book is going to be elaborating on that third question, isn't it? Exactly, yeah. So
I hope so.
Good, great, we can't wait. So we posed a few questions earlier, so I want to turn it back over to Tabji to go ahead and tackle that first one, if you would.
The first one being why Pashukanis today. Yeah. So I think like why, well, I guess this ties into like the fact that it's 100-year anniversary. Yeah, like the fact that like General Theory of Law and Marxism was written 100 years ago, and it's remarkably ahead of the curve. It's not even that like Pashukanis like anticipates people writing 30 or 40 or 50 years later, but it's still current now. To pick on one aspect that I think will also answer the question of what's his relevance now, is the last chapter of the book on law and the violation of law, where he offers a genealogy of prisons and of kind of punishments in court and that kind of thing, which anticipates Foucault and contemporary discussions. So there's a few things about it. One of them is the clear linkage between punishment and money. And specifically, really rounding out his discussion of law as a system of liabilities. This being, like, for him, the main difference between law and just like rules in general. And his funny example of trains, when like train stations or conductors have rules, it's for like safely getting the train from point A to point B. If you get kicked off the train, it's for the safety of the train. That's not a matter of law. It becomes a matter of law where if you get kicked off the train, you get fined, and now you are liable to pay these fines. It's law when it is a matter of property specifically. So this is also what ends up framing law breaking. And he has a discussion of like when people are in court and someone's getting sentenced, you know, we're all waiting to hear if it's guilty or not guilty. And like that's important. But the real kicker is like, how many years are you going to have to pay? How much of your time or your life will you have to give up proportionate to the price of, well, effectively the contract you've broken. So that discussion is of a lot of contemporary relevance for people interested in prisons. Second is with policing and the question of the legal subject and why the police is implied by the legal subject itself. Specifically, the fact that two things. One, law is a system of liability, and to be a legal subject, or at least a good one, is you have to be the kind of person who can be trusted to actually make good on the promises you make, repay your debts, be creditworthy, and so on and so forth. And given that the legal subject is one who has mastery over one's will, that is how you repay your promises, by demonstrating that you are master over your will. But we don't really know in advance who is or isn't master over their will. In fact, the whole idea of self-mastery kind of produces a problem, which is that, like, I can decide to repay my debts. I can also decide not to. I can decide to punch a debt collector. So people, both internally and externally, need to be policed. They need to police themselves. They need to show restraint. They need to show that they are rational and also restrained externally by a kind of organized force who sort of embodies, well, I guess embodies the form of legal subjectivity, as in there is a police department because there are legal subjects. There's a certain way that like police departments is sort of like the collective of legal subjects transferring this need to punch each other if necessary to people with badges and really ugly sunglasses. So Pashukanis, I think, then gives us already 100 years ago a good outline of like why there are police and prisons in the first place. And that's a good reason, I think, why to read Pashukanis today.
Absolutely. That's why I said at a conference recently that Pashukanis was an abolitionist before it was cool. Although although I think that's kind of a flippant thing to say in a way, because abolition was always cool. And anyway, it would have been great to have Pashukanis here today. Somebody's asking in the questions as well, does Pashukanis give any advice to, I paraphrase, to progressives today about what we should do with the state in the meantime? So I wanted to come back to this point of the legal subjectivity and the way we internalize, right? So you have the cop on the street, but you also have the cop in your head, right? So this this quote that I pasted in a chat refers to that the rare gift. So the perfection of the legal subject occurs after he has become slavishly dependent on economic relations, which arise behind his back in the shape of the law of value. The economically active subject, now as a legal subject, acquires, in compensation as it were, a rare gift, will, juridically constituted, which makes him absolutely free and equal to other owners of commodities like himself. And so that is, of course, the property owning cis male white European legal subject, and that becomes then the standard. That person who has, as it were, the full complement of rights, and that becomes the standard then that others are both defined against and aspire to be like formally and materially equalized to. And that is that sort of cop in your head type situation, right? Where you feel that, where you not just feel, but where the system is such that in order to survive, like your bare survival, your access to healthcare, food, housing, employment, etc., you have to engage with the legal system. You have to act as if you were a formally equal person, and as if you're a materially legal person that is able to bargain freely and engage in a contract. So you have to, as if you were equal to your landlord, your employer, etc. So in order to satisfy your most basic needs, you need to submit to the legal system and phrase your needs in legal terms. And that becomes not just something that is about the sort of employment, food, housing, etc., but that becomes like about self-actualization as well. So the one of the main points that I guess we keep coming back to is this idea of law's emancipatory potential, right? So as I said in the beginning, that a lot of our social movements, for example, call for human rights recognition of particular the legal status of the state of Palestine, for example, or we ask for the International Criminal Court to prosecute war criminals or those perpetrating genocide and so on and so forth. We articulate our claims as social movement actors or as citizens as legal claims. Now, Pashukanis understands, as you just explained as well, Tabji, that criminal law, including international criminal law, but also including human rights law, and the sort of nice side of law that isn't punitive, but that we think of as emancipatory, right? So human rights law and sort of equality law and so on, we think of normally as emancipatory. But those exist within the same system and are actually conceived with the same logic, right? So as you just explained, that criminal law is a transactional law and involves payment in years for a wrong done, or like a material harm caused, etc. Although sometimes it is a moral harm rather than sort of a strict material harm. But everything, the juridification of relationships makes everything accountable, as it were, like literally accountable. You can put a figure on a liability or a risk, a liability incurred or a risk averted, etc. Right. So when I've written about corporate accountability and the need then for individuals who've been sort of harmed by corporations or like multinationals, especially in the global south, and those struggles get translated into human rights demands that need to be articulated in Western or European courts, and end up often being paid off if they're at all recognized in the courts, or sort of in some out of court settlement. They are negotiated over within a sort of market of how much is my brand going to suffer from the harm that's now in the papers that I've caused you. And you're having to articulate how much am I willing to accept to make good for this, the harm that my life, my health, my land, my family, my community has experienced, right? So everything eventually within capitalist law is something that becomes expressible in terms of value. So I know that somebody asked in the chat as well about people not being recognized as legal subjects, right? So there are, of course, people classified as illegal, or as those living on the margins of society, or those not recognized in a particular state. But in order to, if your struggle, it is clear that in order to achieve our needs for survival, it is, as I said in the beginning, necessary to be recognized, to be able to go into a shop and buy food, or to go to a landlord and ask for a rental contract, for example, or to get your healthcare needs met. It is necessary to engage within the capitalist system. But ultimately, what we need is not legal emancipation, as Marx also talks about this on the Jewish question, but human emancipation, right? We need to not be strive for acceptance and incorporation within the current capitalist legal system as it is, but we need to overthrow it and do it and tear it down, right? Burn it down. And that human emancipation, that's something that I think perhaps Cordelia is writing about, and we'll perhaps pick up on, and we can, if not, I can also come back to that. The alternatives we are building, need to build, etc. Once we get rid of law, or even before we get rid of law as well already.
This, I think, doubles in a way as another reason why Pashukanis, but I think the implicit recognition that Pashukanis has is that vis-a-vis alternatives, well, something like to each according to their need is already quite substantial. And it's substantial in a way that isn't necessarily handled adequately in what we get from something like Marx's work itself, from the socialist political tradition. And I think the challenge that Pashukanis is willing to raise to this is to say, what to each according to their need really implies is already kind of unspeakably radical, because what it totally excludes is all of the categories of reasoning which we ordinarily encounter in talking about who gets what, who deserves what. It implies we've done away with you're owed certain things and not others. We've done away with torts and desert. And Pashukanis not only is willing to, I think, correctly wrap all of these up in bourgeois right, he, I think, is very helpful for opening the door to the question of and that what then question is actually relatively difficult to answer, because we're not accustomed to doing something like political, even day-to-day moral reasoning without the vocabulary of concepts that give us things like desert, ownership, even, you know, subjectivity. There isn't really a tradition of political or ethical thought in the West after something like the 18th century, besides in a very confused light, maybe very early Benthamite utilitarianism, which attempts to think something like political, ethical thought without a concept of the subject, desert, or rights. And so Pashukanis is, I think, maybe one of the only theorists who is willing to tell you that that needs to be burnt to the ground. And even though I think he doesn't really get very nitty gritty about how it is he would handle these kinds of problems otherwise, as far as alternatives go. I think he has an offhand remark where he compares it at some point to engineering, which I find very funny. But I think reading the general theory, I think really prompts this kind of thought, because it makes you realize how little you've thought about how it is you would talk or form judgments about how to interact with people, who gets what, how we organize this, how we organize that, without the repertoire of concepts that we pull straight from commodity producing society.
Cool. Tabji, would you like to continue with the next point?
Yeah. Before that, though, I just like want to add on to the last point. That I think that's a really like good description of what is like helpful and striking about Pashukanis, which is the emphasis on the way that these concepts like suffuse our everyday reasoning, and the jarring realization that if you do remove the cop on the street, you very quickly find how much he still lives in your head, in all the terms you use to measure right and wrong, and justice in the first place. And that it's the internalization of these concepts as we've inherited them that kind of materializes the badge and the bad sunglasses on the street to begin with. I think Pashukanis like really understands that problem well. And relatedly, I think part of it has to do with like his, you know, being a smart, well-trained lawyer and also writing in a period of transition. The book came out like during the new economic period, right, in the Soviet Union. So like the question of what does transition mean? Are we even in transition? Has that stopped? Where do we go from here? Is like an active one for him. And I think in a different way, an active one for us. Okay, so the next question, which is what other authors are building on Pashukanis' work? Well, for me, there is one person in particular whose use of Pashukanis has been really illuminating, and that's Anthony Paul Farley, his essay Perfecting Slavery. And particularly the claim that, like, when it comes to emancipation in the Atlantic world, the end of chattel slavery marks the beginning of contract for those newly emancipated. And well, a really clear illustration of this, which takes place in the United States and in a number of other places as well, is that the state basically like buys the slaves from the slave masters, and then having purchased them, says, okay, well, you belong to the public now. You owe us citizenship. So it establishes this kind of permanent debt relation, which entails being a legal subject. So being a legal subject now just is the form of racial subordination. It is the perfection of slavery. So for Farley, like this highlights immediately the limits of like what can be done within the law. The very fact of asking the law to do X and Y for you only serves as evidence of your subordination to it. So it really brings to light the problem of the legal form and our problem of relying on and having to rely on the legal form as we aim to address or redress problems. So yeah, kind of a bind, but I think that brings it into stark relief, as well as the necessity of like overcoming law as kind of what would need to be done next. A related thing that comes up is, so given that for others in the Marxist tradition, specifically the kind of justice or egalitarian tradition, many still hold out hope for the vision that like we can sort of collectively secure the autonomy of each kind of but given that this autonomy would need to be defended because well, because of what was said earlier about how like policing is implicit in the legal form, where you have autonomous subjects, you need people who are capable of making good on their promises and being held liable. So like your free association would still need cops to ensure that like the freely associated producers can be held responsible as subjects, which means also not threatening each other's autonomy. There's an experimental question that comes to mind, which is sort of what would it mean to like not have to reason this way? And thinking about this earlier in the year, there was a helpful kind of set of side notes in Orlando Patterson's Slavery and Social Death, where he is kind of doing some typologies of different societies And there's a certain set of societies where, for us now, we tend to think the way to not be a slave is to be independent. For others, it's the opposite. You don't want to be if you don't want to be a slave, you don't want to be independent. And it's a question not of like autonomy necessarily, but of how obligation is distributed. You're proximate to slavery when there is, say, a single person or small group of people who are subject to many obligations from others in a very concentrated way. And then there is sort of making everyone subject to the obligations or wills of others, but in more even way, which people might feel better about. If subjection to heteronomy is not taken to be sort of capital P problem, which it would have to be within the legal terms we work with, if we don't make that assumption, we can ask the question of like, what could that produce experimentally in terms of forms of practical reasoning and the like.
Yeah, cool. Thank you for that. And again, so much of what you say resonates. So I wanted to also continue a bit about what I was talking about earlier. So I'm mentioning some of the names that I didn't mention earlier. So the person who talks most about sort of the need to engage with for our everyday survival, the current capitalist legal system is somebody called Dean Spade, who's written This Normal Life, I think, is the main text. So Dean Spade, and who's, I think, an anarchist and also an abolitionist, right? And also writes on the kinds of transformative justice or the different kinds of processes that we need to develop, but are also in many cases already using when perhaps the cop in our head is, or you know, our knee-jerk reaction is let's call the police or let's sue them or whatever, right? So, what other types of social processes we need to develop, and what we're also doing, and what certain people in certain communities where you might not want to call the cops for various reasons are already the kinds of things people are already engaging in those communities. So Dean Spade, super recommended. Of course, also talks about this specific legal or legalist narratives that we need to engage in, or sometimes do engage in, and the articulation of our needs in specific institutionalized discourses and categories in order to get, say, the healthcare that we want, or the hormones that we want, or the whatever that we wouldn't get otherwise, right? So Dean Spade. I also wanted to talk about Robert Knox. One of Rob's most best-known articles is his Strategy and Tactics article. So that was published a few years ago. I'll post some of this in the chat as well for your reference. So that's Rob Knox's answer to the question of should we engage with the legal system to try and emancipate ourselves? And his answer is no. With Pashukanis, we can. He's sort of more subtle than that. So he says we can use law to create space and to create time. You know, perhaps if we're trying to agitate against a pipeline that's being built through our land, you know, that we don't want there, then we could challenge the planning permission in court, for example. That will give us time to build an encampment, to bring people to the site and to block the thing or to sabotage the thing or to engage in it with it in some other way, right? So tactically, he says, we can engage with the legal systems, but we must always keep our eye on the prize, as it were, which is revolution. So we mustn't live under the illusion that we can use law strategically to litigate ourselves or to legislate ourselves into sort of revolution or communism, because that isn't going to happen, because law is the system that we need to overthrow. Another person who wrote a really super long article, 80 pages recently, is called Amna Akbar, who is really great. And Amna writes about this concept of non-reformist reforms that you often hear talked about in the sort of progressive legal circles. So again, there the idea is, I mean, there are different definitions given of this idea, but the idea that I'm most sort of okay with, because I do wonder if it's sometimes used as a way of like, okay, let's just call it non-reformist reforms. That allows us to be reformist and still call ourselves, think of ourselves as revolutionary, but actually it's kind of a cop-out. Or it's like us allowing ourselves to stay within our comfort zone, especially as lawyers, because these are the tools we have. This is what we studied so hard for. These are the many years we went to law school and whatever and trained as lawyers. Like law, that's the tools we know how to use. And we're uncomfortable going out in the street and punching a cop or punching the fascist or like building a barricade and doing the other things that other people might be doing that we as those sort of clean living lawyers are a bit scared of. So Amna Akbar does talk about non-reformist reforms also in the social movement context, and does give some examples that are more aligned with the way that Rob Knox talks about them. So creating space, giving time, engaging in order to make some sort of short-term tactical gains, while also keeping our eye on the long-term change that we are building towards. Yeah, I'll hand over to Cordelia.
I think with regard to something like the use of law, especially during something like in the course of something like Pashukanis, outside of the general theory, actually has a great deal of immensely specific writing on this question, because he was at time fairly intimately involved in the development of the early Soviet legal system. When reforms didn't break his way, he wrote on that as well. And so I know there's a collection of selected writings by Pashukanis, which contain several short, medium-length articles where he addresses these rather facially, usually writing to his contemporaries in the Soviet Legal Academy. I think something like, yeah, insofar as Pashukanis doesn't have any sort of kind of prima facie moral purity type reasons to view the use of law or engagement with law as automatically thwarting one of our ends. He is, of course, open to it, but at the same time, Pashukanis in the general theory hits over and over the withering away of law as a kind of benchmark for how close we are to actually realizing our goals in a substantive way. And I think the withering away of law is I would probably argue, I think Pashukanis would as well. You see in Soviet texts from the same period, something like, even in, uh, um, basic texts on political economy by Stalin, something like the stages distinction, lower stage, higher stage, being framed in terms of something like the operation of the law of value. Of course, the law of value is operative in the lower stage. Of course, the law of value is not operative in this way in the higher stage, which broadly squares with more au courant discussion about something like the abolition of value, etc. But in a more immediate way, assessing, well, to what extent do we still have categories of desert or ownership? Or do we have torts? Or do we make judgments as to what people get in situations based on what they did, rather than based on what would be best for them and best for others in absolute terms? And that, I think, is a little easier to hold on to as a kind of benchmark than something like the operation of the law of value. I would imply, and again, I do think that they turn out to be effectively isomorphic, withering away of law, withering away of value, and other associated institutions of commodity producing society. So insofar as he, I think, puts a little meat on the bones of what actually transitioning upward and outward means, I think it is very helpful. Although I don't believe he views this contribution of his as being absolutely theoretically novel. I think he would claim this to be basically continuous with remarks that Marx makes on bourgeois right, etc.
Oh yeah, well, thank you. And Tapsi, I wondered if I could ask you a question, going off script a little bit, but because it's kind of comes up in one of your articles, which I really recommend people read. Although, is it published now? Slavery as Social Form: A Critical Theory in Outline, which is absolutely brilliant, and which is how the first article of yours I read, and why I became completely obsessed, as the young people would say. Thought we must invite Tabji for a conversation. So in the final pages of this this article, you talk about reparations and abolition, or the final section is conclusion, reparations or abolition. And I wondered if you could elaborate a little bit on that. What is that question you're asking there? What is your answer?
Let me see. I'm not entirely sure I remember what I wrote. But I can try and reconstruct something on the spot. I think at the end of the conclusion on abolition and reconstruction, one of the threads I was trying to pull together is, yeah, well, I guess like ending with questions about transition and the fact, the two-sided coin of like, we inherit categories and we work with them, and like, how do we construct new ones in the process, and like trying to thread between two sort of unsatisfying positions. One, which could be sort of waiting for the Martians, is sort of the scroll bearing the categories to come has yet to be revealed, and so we just kind of wait silently something that drops from the sky, or kind of flatly confining ourselves to the ones we have now. So trying to find something that avoids those two things. And I think a related problem of like, well, I think going back to Anthony Farley's point that like slavery finds itself perfected when we all view ourselves as legal subjects, um, which means that kind of legal reparation for slavery is a contradiction in terms because our problem would then be the form of law. So that in itself makes the terms abolition and reconstruction really quite expansive ones. So I think those are the kind of two intertwining threads of not being bound by the categories we inherit, but also contending with the fact that they are the categories we inherit, and that the inheritance of these categories is like the form of what our problem is. So yeah, I think that was the dilemma on the table for me in the conclusion.
Yeah, absolutely. And you also really beautifully cite Sylvia Wynter there. So you summarize Wynter as saying, having named Blackness the internal limits of our political culture, Wynter affirms Black political struggle and with it Black studies as the movement towards the dissolution of the present organization of knowledge, a movement that proceeds by revealing the contingency of the social structure. In doing so, it points to the potential for reigniting the politics of being, reopening sedimented philosophical and theological questions, and denaturalizing the repetition of racial violence. The demands of radical Black political and intellectual discourse begets a critical project in which the overcoming of the present order is inseparable from adjudicating its conditions of possibility. It is the jobless and unskilled so-called surplus populations of the world's ghettos, shantytowns, and favelas who reveal the truth of our society. Their struggle for the necessities of life is a struggle to transform the meaning of life itself. It is the struggle against our narratively condemned status. I thought that was a really powerful conclusion of that amazing essay that everyone should read. I wondered, Cordelia, if you had anything specific you'd like to add, or shall we? I know there's a lot of questions in the chat as well, and I also want to invite people to to ask the question using your voice, if you like. But before we do that, we can also have you come in just to make some further points.
Well, on the topic of top G Fachschrift, I wanted to give recognition as well to another article of theirs, which appeared in Philosophy Today, Materialism, Freedom, Self-Consciousness, which I think makes a very a point which I find to be pretty sympathetic to the kind of critique of freedom that we get out of Pashukanis. I personally found it incredibly insightful. It did in large part sell me on the position towards the end you take, constructing the origin of freedom as slavery. And I think the linkage between something like a critique of moral, juridical, political subjectivity, and its origins ultimately in something like the the image of the slave, the slave is the kind of obverse against which this becomes possible. Yeah, I found to be very compelling, both theoretically as well as genealogically. So I would encourage people to check it out as well. I think I wish actually that Pashukanis had more to say than he does about something like the slave trade and the early history of apologetics for and theories of slavery in the European political and legal tradition. Although I'm sure that that's in large part a lacuna that you're going to fill. It sounds like in the next couple years in your own work. But yeah, I think the parallels are very immediate, and the kind of slip from talking about autonomy, freedom as having a kind of possession or ownership over these over these zones of our own sort of ostensibly self-directed free activity, whether that shows up in the Ficta passage that Pashukanis talks about, or whether that shows up in a kind of unreflective concept of free association. The way in which you can pull out of that the conceit of owning activity of subjects in this way, I find to be both very thought-provoking as well as somewhat alarming. I think it kind of adds one other genealogical arrow to the quiver for Pashukanis in writing up these ideas, both as they come to appear and as they stabilize particular configurations of institutions on behalf of commodity production.
Yeah, thank you. And I think that we need to keep in mind also that there's a lot of Pashukanis writing that hasn't been published in English yet, although the historical materialism did just publish 3 new pieces in English. Those of you who can read German or Russian, of course, have access to more. I do know that there's an article on international law that is appended to China Mieville's Between Equal Rights, the Marxist theory of international law. I want to open it up to questions. I did see a question in the chat by Z Antonio. So is there something to be criticized regarding the humanist modernist form of future-oriented emancipation advocated by Pashukanis, regarding especially decolonial ecological critiques in that regard? Is it possible to conciliate useful aspects of Pashukanis with such contemporary critiques of modern forms of emancipation? Well, I would think that Marx, as well as, I think, as Cordelia has also pointed out, Pashukanis in most places stays very close to Marx. And when you talk about from each according to their needs, to each according to, from each according to their ability, to each according to their need, you, by virtue of that already, exclude what our fellow Londoner Aaron Bastani calls a fully automated luxury communism, right? So definitely not, I would say. I think Pashukanis would be with me in saying that that is a fully ludicrous idea for various reasons. Also, I don't think we need to be too concerned about finding and translating every single piece that Pashukanis has written, because as we've seen today, and as we see in other writing as well, and in other people's work as well, we are, it's not about the author and who said exactly what. We are all doing this work, right? We're all doing, Tabji is doing amazing work, Adelia is doing amazing work. Can't wait for your book. And lots of other people are doing amazing work that is filling gaps that you know, stuff that he might have said or maybe never did say or think about or whatever. So there are some other, so I figured Z Antonio, because you asked several questions in the chat, but I also wondered if that last question was perhaps perhaps a question that you're asking that you yourself have an answer to as well. It's one of the, it reads like one of those kinds of questions. You have ideas about this. So I'd like to invite you to come in and tell us your thoughts as well, and anyone else as well who's willing to speak. Please raise your hand. I do also see another hand as well, but I want to also make sure that we don't skip anything that is already in the chat. So somebody wrote in from India. If you'd like to ask your question with using your voice, also please do put up your hand. And South Africa as well. So that was really cool that people are around the world. Great. Yeah, please put up your hands. I see Simon. Perhaps we can move over to Simon and let you ask your question.
Hi, thanks for all of your talking and your interesting reading recommendations. I've got a question to Kritje Bas. I was like a little bit surprised when you said like at the beginning, for Pashukanis law originates in state power and class power, because I understand him like a little bit different. He says, okay, when he discusses this guy, I think Piotr, yeah, never mind, like another Russian theoretician, he says, okay, like the content has always to do like with, let's say, class power, but I'm like more interested like in the form of law. And that doesn't originate out of state power or out of class power. It originates in like in the exchange relation. And I mean, this is a relation, a social relation, material conditions, that is also like a kind of relation of sorry, I'm missing like the English word, recognition, sorry. So I think this is much different, because he does not only criticize like theoreticians like Kelsen, where like the law comes out of the norm, but also like out of state power and out of class power. And I was also like a little bit surprised when you said let's break the law, brechen. Because I think his perspective is much more like this withering away, absterben. He talks of a like unmeasurably long time in the future where law withers away, and says like this is like question like of a future classless society. And one last remark. He says, okay, I'm criticizing this individualistic liberal theory of law, but there are also like in his time, besides like his own critique, other critiques, and he calls them critiques from the viewpoint of the bourgeois state socialism, of imperialism, of the dictatorship of financial capitalism. So I think, yeah, I mean, you have this abolitionist perspective, but I'm interested in how you see, do you see also any dangers if there isn't a law form? I mean, like slavery, or you mentioned like the people like in occupied Palestine. And I mean, these people are not really legal subjects in that sense. And if you imagine like a society beyond commodity exchange and the law form, then I mean, this can be easily be also like backlash like behind like to feudalism in some way and so on. So I would yeah, maybe you could yeah, just comment or three of you on that. Yeah, how can we think of social relations that of the future that maybe don't go behind like the form of law, because it's at least a form of recognition. So
yeah, thanks. As to your first point, no, I didn't say that because I said most Marxists, when they talk about law, talk about it as a form of class or state power only, right? So they only talk about the content, whereas it's Pashukanis who goes deeper than that and actually says we need to talk about the form of law, and that is the problem. And because of that, the form of law being specifically, as he explains it to be, it is also that vessel into which we cannot pour socialist content to just have like a socialist law, right? So that is why we need to get rid of law. And I think, yeah, maybe the word "behen," I didn't mean break law as in let's break the law as in, because then you're still sort of engaging with the law, but in a sort of like subversive way. I meant more yeah, I think there was a whole debate around withering away and whether if you're reading, for example, this text by Engels in which he summarizes, I can't think of it right now, but anyway, he summarizes the sort of withering away of the state idea, and he uses in English, it's translated as smashing in. So there's a debate around how words are translated in some of the texts, right? So like when we say, and there's a debate to be had over, okay, how is it actually, what's it actually going to look like when it comes to smashing? Or are we already like, is there a transition? Are we already in the revolution? Are we already doing the things that cause the state to eventually cease to exist, right? So I don't think it's that necessary to have like a really clear perspective on what the revolutionary process may or may not look like. One thing on Palestine, right? So that question, the question of will there not be chaos? That's kind of like the question anarchists get asked a lot, right? And I think that Pashukanis is also a place where we can see the sort of marriage of anarchism and communism, or we can see that communism is actually, at the end of the day, the same goal as what anarchists are ultimately fighting for. So that is the question: won't anarchism just be chaos? And it won't be, because being a communist requires that leap of faith, that sort of belief in I know that human nature is not something we like to talk about, but this idea that we are social beings and we do want to live in harmony with each other, and that you know, if you don't believe that in that, then there's no point even being a communist. So in terms of Palestine, right? So one other text I wanted to mention was Iman Abdelhadi and Emmy O'Brien together wrote an amazing a work of speculative fiction called Everything for Everyone. And this is a oral history from the New York Commune, written in the year 2072, in which both Emmy O'Brien and Iman Abdelhadi, who's Palestinian, are little old ladies interviewing people who were key in the process of turning the whole world into one giant commune, or into several smaller communes, actually. And there, in fact, I was at a reading, right, at a book event where a man actually read from a chapter that where the interviewee describes the moment that kicks off the move towards communization in the Levant, which is actually the moment when Palestinians liberate themselves through bursting out of Gaza, and it's actually incredibly intense to think about that at this point, and to also see how they then describe like what happens after that, and of course comparing that to what's happening today. I don't know. I have a lot of thoughts on this, but I think if I start talking about Gaza, it may completely derail the conversation. So other than obviously free Palestine, and I do think that Palestinian liberation and the way that Gazans, in their act of everyday survival, we teach life and teach liberation in a way that is inspirational, infectious, and unbelievably powerful and strong, in a way that hopefully undoubtedly will have effects around the world in a positive sense. Beyond that, I'll leave it there for now. Yeah, either Tabji or Cordelia, please feel free.
Yeah, I might add just one thing to what River said in response to Simon's question. I think that the point that you made about seeing in Pashukanis's work why something like the classic like anarchist communist distinction doesn't hold is exactly right. And I think the reason why is that Pashukanis is perhaps the theorist I would want to most strongly identify with something like the position that Marx takes only early in his life, in his critique of Hegel's philosophy of right, where he, in spite of not possessing really a very adequate analysis of something like reconciliation, Marx has one very good point, which is simply that I don't see why we ought to live in a society where you put on your burger hat to go to market and screw everyone else over, and then you're supposed to go home and put your citizen hat back on and then work against the decisions that you made in the first instance. This just doesn't make any sense. This isn't how we should live together. And so what it would mean to live without legal categories as we're accustomed to them is what it would mean to live without this distinction. And as far as the practical side of this goes, how we go about mediating these kinds of interactions, making these kinds of judgments without, as you said, going behind people's backs. I think Pashukanis intuitively is something of like an institutionalist in a very gentle sense. I don't think he has really very fully developed remarks on this. But I think the direction that you would want to lead after Pashukanis's work and his reading of Marx would be something like saying, well, without this distinction, there isn't really any kind of gap between the things in which I ought to have input and the things in which I don't, or the kinds of institutions or decisions or processes that I'm involved in, and the kinds that I oughtn't be involved in, insofar as, we're interested in all of them for the same reason, which is meeting others' needs writ large. And so the direction where you would be led by this would be one of something like a kind of transparent institutionalism, where we have a kind of big system, probably internally heterogeneous system of ways of making these decisions, of talking to each other, and of attempting to get to the core of what making this decision over that decision means for, as Pashukanis would say, benefit, harm, or as you would pull out of Marx, need. But at the same time, because we lose this public-private distinction, we lose like a state, corporation, non-civil society, non-state distinction. There's no sense in which anybody isn't involved with this kind of activity. And so we would expect everyone to really have the capacity to have the same insight into how it is we make these decisions, the same kind of input, and for this to become for all of this kind of decision to be something like how decisions are made within organizations, within groups, rather than how they're made when they are mediated by a legal system imposing a fixed concepts of what's owed in some scenario, of the as Pashukanis said, the kind of social minimum upon what could otherwise be a more open-ended decision.
Yeah, I have a similar thought as well, in that I read Pashukanis as sort of like distinguishing, I guess, between legal forms of mediation and possible communist forms of mediation. But in either case, we still had mediation. So it's the question of like what serves as sort of the rule or organizing principles for how we regulate ourselves and mediate our relations to each other. And yeah, as Cordelia said, like when he makes these points, he does dip into the early Marx a bit. Reading him yesterday, I paid more attention to the quotations from On the Jewish Question, which I think ties into his remarks on like the ambiguities of the ethical form, where there's a like if your landlord evicts you, but shows up and says, I wanted to tell you early because blah blah blah, and thinks this is doing like a nice thing. It's like, well, legally it is the nice thing to do. It's fully within the realm of law, and also it is not in fact a nice thing to do. So it's like, you have, if you're a landlord, you're objectively doing bad things, and you make up for it by being a nice person on an individual level. You have to make up for, individually, you have to make up for the bad things you do with your burger hat. And this is just nonsensical. Rather than have to be two different people, just be a single person, and figure out how like regulate and mediate relations between single person in this.
Okay, cool. I again wanted to ask Z Antonio if you wanted to come in and ask your question, or anyone else within the room, or even answer your own question, because I said perhaps when you were away that the question about ecology sounds like something that you have ideas about that maybe you'd like to share.
Thanks. Thanks for the whole discussion, which is really interesting. I'm not sure I can answer the question. It's something that I've been thinking about because I'm also like interested in Pashukanis recently, and I plan to try to investigate more or less towards this direction. I'm generally interested in the relation between law and like cosmological difference. So difference in, different metaphysics that you can start from, which might be other than Western, etc., and the relation between that and the ecological question. And at the same time, I'm interested in sort of mediating that with critique of capitalism and large scale politics and stuff like that. You know, usually you have a contrast between a politics that is more anarchistic and localist and network that has more sensibility to questions of, you know, indigenous peoples and ecology and stuff like that. And then you have other kinds of ways of thinking and acting that are more concerned with capitalism and large scale technological reform of, you know, planetary scale questions. And I'm interested in mediating between those things. And Pashukanis, at least the way that I find him being discussed, usually is more connected to the latter side, so more kind of Promethean politics of, you know, large scale transformation of the economic order, and you might relate that to also, you know, alternative modes of governance that might substitute for capitalistic markets and stuff like that. And also, this seems to have a bigger affinity with like modernism, right? So modern kind of politics in the sense of this idea of progression in time in which you will eventually surpass a certain phase of the history of humanity towards a greater emancipation and a greater liberation of humanity as such. And so my question is whether you see any kind of problems there in terms of this conception of liberation, its relation to the idea of humanity, with the distinction between humanity and nature. Does it presuppose, like, does the emancipation of humanity and communism and with this idea of withering away of law, does it presuppose a subjugation of the non-human, or can this emancipation be an emancipation of everyone else? Because, you know, usually in the other side of this discussion, these more ecologically oriented approaches tend to be suspicious of the idea of emancipation. So instead of emancipation, you have, you know, sort of a multilateral heteronomy. You're not trying to be freed, but you're trying to be connected in a way that is sustainable and that makes sense. That's not exactly about freedom, at least in the modern sense. So that would be my question. Thanks.
I think just to share a couple initial thoughts on your question. Pashukanis, I want to say, would be drawn towards something like a way of dissolving the distinction that looks like this. On the one hand, the withering away of law implies that there isn't a characteristic way that decisions have to be made. We lose a kind of we lose a kind of standard. We're able to include a significantly broader set of ways judging how we want to handle some kind of matter. So we don't, so, you know, in the case of the sorts of things that are handled by courts now, we, you know, appropriate remedy isn't always finding the amount, taking it from one, giving it to another, you know, punishing this person in this way, that person in that way. And so intuitively, I think there's a lot which seems as if it would be quite genial to a kind of opening up of our political picture to ways of making decisions as communities, which don't necessarily need to hold together, nor even necessarily need to use common, totally common sets of concepts. But on the other hand, I think the other implication of nothing being characteristically mine and nothing being characteristically yours is that there actually aren't any people to whom we're, in the final instance, not accountable. nor is there any matter about which we find ourselves not being able to say something. And by this I mean when we lose the distinction of interests or domains of activity which accrue to particular people instead of others, that you know, and this I think is what it means to have, as Tachi was saying, a kind of distinctively communist form of mediation. We also aren't in the position of saying, well, you do it like this over here. And of course, you know, it would be better if you considered these people over here as well, but you don't have to because they don't live where you live, or because you historically have had this land and these resources and they haven't. And we find ourselves in a really hardening way, unable to make those kinds of claims about these things belonging to these people specifically for these reasons. And so I think at the same time as we have maybe a much broader set of ways we could find ourselves making these kinds of decisions, we also find ourselves both being held accountable by a society rather than a specific group of people upon whom we might trespass and thereby generate torts. And we also find ourselves with a potential interest in intervening in decisions that previously we might have thought ourselves sort of like not entitled to get to say something about, even if it does affect us. And so that I think is a fairly open-ended answer to your question. But I hope that maybe adds a little substance to the kind of hand-wavy claim that the distinction between these two poles is in some ways undermined by Pashukanis's work.
Cool, Tabji, would you like to come in? I know you've written an article that also touches on post-humanism.
Yeah, with Pashukanis, I'm thinking again about the claim about reasoning with kind of clear and distinct concepts of harm and benefit, and what could be entailed by making harm and benefit sort of key terms, specifically harm, because I think that like might be able to expand the range of claims that people will make, as people are harmed by all kinds of things. And law really narrows this down in a particular way that I think Pashukanis is trying to get around. If you hurt yourself because of the way the sidewalk is designed, maybe you could, like, I don't know, raise some kind of court case about it, and it might be a liability thing, as opposed to a somewhat more straightforward consideration of what is and isn't harmful or beneficial ways of constructing things. And like people could, I think in principle, weigh in on this without really needing to invoke right or ownership claims. Yeah, this is a loose thought, but like I think there's something about that well, like I get around to some of the narrow focus of law and some of the ways that baggage still carries over in thinking about emancipation.
All right. Do we have any other questions? Anyone else wants to come in? I think it's really cool, by the way, that we have people from Indonesia, South Africa, various other parts of the world. I wanted to make take the opportunity, that question, perhaps I can plug an anarchist text, which is on anti-speciesism. I'll try and find it, but it's a pamphlet. Calling in from Rio. Here we go. All right. Anyone else, or any of our speakers, would you like to have a final comment? We'll try to find this anti-species. Please shout if you do. If you do. No? Okay.
I just wanted to thank you again for organizing this event, River, and to all the attendees who showed up to listen and converse with us. And thanks again as well to anybody who asked a question or participated in the conversation today.
Yeah, it was really good. Thank you for organizing.
Thank you so much, Tabji and Cordelia, for your wisdom and insight and for joining us. And thank you everyone in the room as well for joining us. I can't find the vegan anarchist text right now, but you can Google it and it's linked somewhere in Wikipedia. Very good. So yeah, see you soon. Hopefully we will, we have recorded this, so we will post it on our YouTube channel. If you go to YouTube, search for Center for Law and Social Change. Also, go to Twitter, find us there, at Law Social Change, and we will post the link there to the video as well. If you did say anything that you wake up in the middle of tonight thinking, oh my God, please edit that out, then drop us a line and we can edit that out. And if not, we'll hope to see you soon. Hopefully you'll be okay with us sending spam about our future events to the emails that you registered with. I really hope that's okay. And see you soon. Thank you so much. Free Palestine. Love you all. Bye.